Welcome to the deep dive. So imagine you're in a situation, right, where your future really hangs in the balance. Maybe you're fighting to stay safe, or maybe protect your interests. Could be an important insurance claim, maybe a dispute with the local council, something like that. And a really big decision gets made. But then, you find out it's not quite the final decision. So when do you appeal? When does that critical deadline, actually start ticking? This might seem like a super technical question just about timing, but honestly, it has huge real-world implications. And the Supreme Court just weighed in on a case that, well, it really untangles exactly this. It gets into fundamental questions about how justice actually works.
Yeah, and what's really fascinating here is how the court, in this case Riley v. Bondi, Attorney General, it's decided just recently, June 26, 2025, how it clarifies things. It's not just about the specifics of this one immigration case, but really the fundamental principles of when a person can challenge, any administrative decision. And crucially, it defines what happens if they miss that deadline.
Yeah.
Because there's distinction, right, between a rule a court must enforce, like no exceptions, and one where it may be flexible if the circumstances warrant it. That was precisely what had the lower courts divided. So this ruling is, well, it's pretty pivotal.
Right. And to really get a feel for the stakes, for what these questions actually mean for people, we need the human story. At the heart of this whole legal battle is a man named Pierre Riley. He's a citizen of Jamaica. And his story, it really brings these abstract legal questions right down to earth, makes them sharp. So Riley came to the U.S. way back 1995. He was on a tourist visa, just 16 years old, but he ended up overstaying. Life went on, and then in 2008, he was convicted of some pretty serious offenses, drug trafficking, conspiracy, and firearm possession. And he got a hefty sentence for those crimes, 25 years in prison.
Yeah, that's a huge chunk of someone's life. And after serving nearly 15 years, Riley was released from prison, January 2021. But almost immediately, right away, his legal troubles just shifted focus from criminal justice over to immigration. The Department of Homeland Security, DHS, moved to remove him, deport him from the U.S. because of that aggravated felony conviction. And this wasn't, a typical lengthy immigration court process. It's something called streamlined removal. Basically, instead of a full hearing up front with an immigration judge, an immigration officer can directly issue what's called a Final Administrative Review Order, or FARO. That order directs the person's deportation. It makes the whole process much faster, usually. But as we'll see, it can also make things potentially confusing when it comes to appeal timelines.
Okay, and this is where Riley's case takes a really critical turn. It moves beyond just if he's being removed to a much more specific and frankly terrifying concern about where he's being sent. Riley wasn't actually fighting the fact that he was removable from the U.S. altogether. What he was vehemently resisting, what he was fighting against, was being sent back to Jamaica.
Exactly. He sought relief under something called the Convention Against Torture, or CAT. This is a really important international treaty. The U.S. is a party to it, and it basically prohibits sending someone to a country where they are more likely than not, to be tortured.
Yeah.
And Riley made this compelling claim, a terrifying claim, really. He said that a wealthy, very powerful Jamaican drug kingpin, someone he claimed had serious influence, even with police and politicians there, would kill him if he returned. And he didn't just say it. He provided evidence to back it up. Things like death certificates for two of his cousins who he claimed this kingpin had already murdered, plus letters from family members supporting his fears. But it's a really high-stakes claim.
Wow. So his case then goes through several layers of review, right? What happened next?
Well, first, an immigration officer looked at his CAT claim and denied it.
Okay.
But then it went to an immigration judge, an IJ. The IJ listened, disagreed with the officer, actually found Riley to be credible, believable. And the IJ granted him what's called a deferral of removal to Jamaica, meaning, okay, you might be removed, but not there, not to that specific danger.
So that sounds like a win for him, at least on that front.
It was, but DHS, the government, wasn't done. They appealed the IJ's decision up to the Board of Immigration Appeals, the BIA. And the BIA, well, they vacated the IJ's order, they overturned it. They ruled that Riley's claim wasn't supported by sufficient objective evidence. That's the standard they used. And that decision essentially allowed the initial FARO, the order for his deportation, to be enforced again.
Oh, okay. So the deportation order is back on. And what did Riley do then?
He acted fast. 3 days later, he filed a petition for review in the Fourth Circuit Court of Appeals.
And it was that fast filing, that petition to the Fourth Circuit, that really teed up these two huge legal questions for the Supreme Court, right?
Exactly. Because the Fourth Circuit looked at his petition and dismissed it. They said they didn't have jurisdiction, basically arguing he filed too late.
Yeah.
And the decision hinged on these two very specific points, the ones the Supreme Court then had to step in and clarify for everybody.
Okay, so these two questions, the when do you file and the what happens if you miss it, they're super central. And honestly, they feel relevant for anyone navigating some complex system, not just immigration. Let's really dig into that first one. When is a final order of removal actually final? What was the core disagreement there?
Okay, so the tension was this. Riley filed his appeal to the Fourth Circuit within 30 days of the BIA's decision on his CCAT claim. That was in May 2022. And that seems reasonable, right? That was the last administrative word on, where he could be sent, the torture claim.
Yeah, makes sense.
But the initial FARO from DHS, the order that just said you're being removed, that was issued way back in January 2021, over a year earlier.
Ah, okay. Big difference.
Huge difference. So which date starts the 30-day clock? The Supreme Court's majority, Justice Alito, wrote the opinion. They sided with the earlier date. They held that BIA orders denying SAT relief, specifically in what are called withholding-only proceedings. These are proceedings focused only on protection from torture after you've already been ordered removed. Those CAT denial orders are not themselves final orders of removal.
Okay, so they're separating the order to remove from the decision about torture protection.
Exactly. They said the FAO, the one DHS issued back in January 2021, that was the final order of removal. Why? Because that was the order that concluded Riley was deportable and ordered his removal. Think of it like this. The order of removal is the first big decision. You have to leave the country. The FEA claim is a separate, although related, issue. It's not about if you leave, but about where you absolutely cannot be sent because it's too dangerous. So the court basically said that first decision, the one saying you got to go, that's the one that starts the 30-day appeal clock for removal itself, even if you're still fighting about the specific destination.
Yeah.
And their reasoning, well, it came down to the wording in the statutes and also some previous Supreme Court decisions, cases like Nasrallah and Guzman-Chavez, which basically established that CIR orders don't undo the finality of the removal order itself.
Wow. Okay, so the court says the clock starts way, way back with that initial deportation order, not the later decision on where you can't go. It feels pretty counterintuitive for a lot of people, I'd imagine. How did the dissenting justices argue against this? What was their take?
Oh, they argued strongly. Justice Sotomayor wrote the dissent, and she called the majority's conclusion absurd and incoherent. Pretty strong language.
Yeah, that's direct.
Her view was that Riley's order of removal shouldn't become final for appeal purposes until the BIA actually ruled on his SCOTUS claim. Her core point was, look, you shouldn't be required to appeal an order before it even, fully exists in its final form, addressing all related parts. She argued that the normal statutory definition of finality, which usually involves BIA review, doesn't really fit these streamlined removal cases where there's no BIA review of the initial FARO itself. The majority's idea that an appeal period just sort of expires instantly if you never really had a clear starting point linked to the final outcome, she said that makes no sense.
So she focused more on the practical reality of when the whole picture is clear.
Exactly. Justice Sotomayor talked about the ordinary meaning of final, like the endpoint, the terminal event, and she leaned on centuries of legal precedent that generally frowns upon piecemeal litigation.
Meaning appealing bits and pieces separately?
Right. When the law itself says multiple issues, like the removal order and the CAT claim, have to be consolidated into a single appeal petition, which it does here, she argued they should become final together for appeal timing purposes. She also slammed the majority's approach for basically forcing people like Riley to file what she called pointless premature petitions. Yeah. You'd have to guess and file an appeal on the removal order maybe before you even know the outcome of your CAT claim, just to be safe. She called it chaos and said it serves no function. It basically shifts all the burden onto the individual to navigate this really complex, potentially illogical timeline.
Okay, so the when is definitely complicated. A real split there on the court about when that clock starts. But then there's the second big question. What if I miss it? Let's say the clock did start earlier than you thought. Is that 30-day deadline like a concrete wall, an absolute hard stop, no exceptions allowed? Or is there maybe some, wiggle room? You used the analogy earlier, like a strict speed limit versus needing a driver's license. One's about how you operate, the other's about whether you can operate at all. This difference between a jurisdictional rule and a claims processing rule seems absolutely crucial, not just in immigration, but maybe if you're challenging, a tax assessment or something from a government agency.
That's a perfect analogy, and it really gets to the core of this second question. And here the outcome was different. The Supreme Court's majority, again with Justice Alito writing, held that the 30-day filing deadline in the relevant law, Section 1252b1, is a claims processing rule.
Right.
It is not a jurisdictional requirement. And this is a really significant distinction for you, the listener, to understand.
Okay, so what does that practically mean? Claims processing, not jurisdictional.
Well, the court explained that they're generally pretty reluctant to call a rule jurisdictional, unless Congress has made it crystal clear that's what they intended. Congress doesn't have to use, specific magic words, but the signal has to be really, really strong. Unmistakable. And looking at the law here, they found the text simply tells aliens what they must do to get their case reviewed by a court. It doesn't actually give any directives to courts or talk about limiting the court's power or jurisdiction. It doesn't say courts cannot hear this case if the deadline is missed. It says aliens must file within 30 days. That's a subtle but key difference in focus. Plus, where the rule was placed in the overall statute also suggested it wasn't meant to be about the court's fundamental power to hear the case.
Okay, so the impact of that finding sounds huge. It means a court isn't automatically forced to throw out a case just because it missed that 30-day mark?
Exactly. It means the court can potentially hear a case even if the deadline was missed. For instance, if the other side here, the government doesn't object to the late filing, or if there were compelling reasons for the delay, what lawyers call equitable considerations. Think fairness, basically. And in Riley's own case, this was critical because the government actually told the court it does not wish to press that ground for dismissal. They weren't going to fight him on the timing issue.
Yeah.
So because the rule isn't jurisdictional, the government could waive the argument, and the case can now go back down to the Fourth Circuit to be heard on the merits of his scattered claim.
That gives him a real lifeline then, where it looked like the door was slammed shut. But you mentioned a twist, another layer from one of the justices.
Yes, a fascinating one from Justice Thomas. He wrote a separate concurring opinion. He agreed with the majority that yes, the 30-day deadline isn't jurisdictional. So far, so good for Riley. However, Justice Thomas then raised a completely different potential jurisdictional problem. He pointed out that generally, federal courts don't have jurisdiction to review CI orders by themselves. They can only review them as part of the review of a final order of removal. Remember, Riley's petition to the Fourth Circuit only asked them to review the BIA's CI order. He didn't explicitly ask them to review the original FARO, the thing the majority just defined as the final order of removal.
Oh, I see. So even if the timing isn't a barrier anymore.
Right. Justice Thomas is suggesting the Fourth Circuit might still lack jurisdiction on remand, not because the appeal was late, but because Riley appealed the wrong type of order, or at least didn't package it correctly with the final removal order. It's like you got through the security check, the timing isn't jurisdictional, but you might still be at the wrong departure gate, appealing only the CIT order, not the final removal order it's supposed to be attached to.
That's subtle.
Very subtle, but potentially significant. It opens up another possible roadblock for Riley down the line, even after this partial victory.
So the good news is the door isn't slammed shut immediately on the timing issue, but the fine print, the exact legal pathway, still leaves a lot to potentially unravel. Did the dissenting justices, like Justice Sotomayor, have anything to say about the second question, the claims processing part?
Yes, absolutely. Justice Sotomayor, even though she disagreed strongly on the first question about when the order was final, she fully joined the majority on this second point. She agreed the deadline is not jurisdictional. And she emphasized that this is important because it allows for things like equitable tolling.
Meaning the court can pause or extend the deadline for fairness.
Precisely. For example, if someone was misled about the deadline or faced truly extraordinary circumstances that prevented them from filing on time, it adds a necessary safety valve. And she also made a point to note that the government has a constitutional duty under the Fifth Amendment's Due Process Clause to give people clear and adequate notice about these appeal requirements. You can't have hidden traps. She even encouraged the lower courts to try and manage the potential chaos she foresaw from the first ruling. She suggested they could hold in abeyance, basically pause any premature appeals that people might now file to avoid that whole protective appeal mess.
Okay, so we've really journeyed through some complex legal territory here. We've navigated final orders, jurisdictional rules, all through the lens of Pierre Riley's very compelling, very human story. The Supreme Court's decision in Riley v. Bondi, it definitely provides some clarity on these procedures, but gosh, it also really highlights the incredible stakes involved and how these intricate, almost technical details can completely shape a person's life and future.
Absolutely. So the key takeaways. We learned that the initial removal order, that FARO in Riley's case, is generally considered the final order of removal for appeal timing, even if other related relief, like a SAC claim, is still being decided later. That clock starts early. But importantly, we also learned that the 30-day deadline to appeal that order is a claims processing rule. It's mandatory, but not jurisdictional. That offers some crucial flexibility for courts to potentially excuse late filings if fairness demands it or the government doesn't object. Still, as Justice Thomas's concurrence reminds us, clearing one hurdle, like timing, doesn't mean the path is clear. There might be other jurisdictional questions lurking, like what exactly you appealed. It's just a powerful illustration, isn't it? How specific words, specific interpretations of legal language can have these profound real-world effects on finality, the chance for someone to have their case heard.
It really is. And it makes you think, how these concepts might apply in other parts of life. Maybe you're appealing an insurance claim denial or a decision from the tax authorities, or even facing some kind of disciplinary action at work. When does that countdown clock truly begin for you to challenge it? And what are the hidden rules, the jurisdictional versus claims processing distinctions maybe that could change everything about your ability to fight back? This deep dive really shows us that being genuinely well-informed isn't just about knowing the final outcome. It's about understanding the intricate machinery, the procedures, and yes, the human stories that are always behind the legal headlines. So what stands out most to you about this case, and how might these kinds of distinctions about when something is truly final and whether deadlines are absolute impact other systems or processes you encounter in your own life? Something to think about.